the general purpose of this webinar is kind of to go over the new developments that affect employers as it relates to lawsuits that can result from workplace injuries, and also to talk about frequent fact patterns that we see and issues that often come up in the lawsuits that we handle, because Sam and I handle quite a few of these lawsuits and were resulting from workplace injuries, and we thought it'd be important to talk about the stuff we see while also trying to mix in stuff that's going to be coming down the road. With that being said, I do want to say that the purpose of this presentation isn't to tell you how to prevent injuries, because Sam and I are not safety experts. So we want to talk more about assuming an injury happens in your workplace. Well, what are the steps and what are the stuff that you need to watch out for in order to avoid potentially costly lawsuit down the road. So this presentation is basically broken up into three components, and those are organized into three things that we see the most often that employers fail to do, and that's first, employers often fail to properly handle reports of injuries or illnesses, and that relates to OSHA requirements. Employers often fail to manage claims for workers' compensation benefits, and that's, of course, workers' compensation law and discrimination law. And then employers often fail to accommodate employees with a disability that results from workplace injuries, and that might involve claims under the ADA or state anti-discrimination laws. So the first thing we want to talk about is, what are the issues when an employee is injured or suffers an illness as a result of work, and they have to report that, and that gets into OSHA. And the whole goal of OSHA, and this kind of helps me when I'm thinking about these issues, is thinking about the big picture of what's going on with each of these statutory provisions. The big picture in OSHA is try to get the employees appropriate treatment and prevent similar incidents from happening in the future. With OSHA, there's a lot of new stuff coming down the road that's going to take effect in this winter and early next year. The first of them is about new reporting requirements that require employers to electronically submit injury and illness data that they are already required to record on-site OSHA and injury illness forms. Sam might have a little more information on what that kind of information would include, so I'll turn it over to him real quick to talk about that.
Well, one thing that I would tell you is remember that there's a difference between the logs that you maintain for OSHA that in essence record your injuries, and completely separate requirement for the reporting of fatalities, injuries that result in hospitalization, amputation, or loss of an eye. Those are two completely different types of regulations. The reporting to OSHA, the serious injuries and fatalities, that new regulation took effect about a year and a half ago. The ones for essentially recording injuries, the type that Mitch was talking about, are ones that are about to take place. So just keep in mind the differences between those.
And that's important because, I mean, really, what's going on here is you're not changing what you're recording, you're changing how you transmit that information to OSHA. And it's kind of funny that this section is part of this presentation, because OSHA's intent in changing these rules was to nudge employers into having safer workplaces by putting their information about injuries out in the public view. And the potential downside of that means that anyone can go on and look, what your record of injuries are, and that would include, union representatives and plaintiffs' lawyers. So, as opposed to ways of preventing lawsuits, OSHA might have given employers another reason to create lawsuits related to workplace injuries.
It also I think, unstated or perhaps stated in a lower voice is the public shame that comes with with having this information out there and available.
Well,
how it could affect, you know, the bottom line in many respects. And OSHA is not real shy about telling you they're going to publish this information that you're reporting to them.
And that was their point, is that we want to shame employers into.
And we now know that public shame can win an election, so it could be a big deal.
The next big thing that's coming down the road as it relates to OSHA and reporting of injuries, and these are new, as opposed to the last slide where it's just you're changing how you report information or record information. These are brand new rules that are coming down from OSHA, and they were originally supposed to be effective in August, but employer groups have filed a lawsuit down in Texas challenging OSHA's authority to make these new rules. So OSHA has delayed the effective date now until November 1st. And under these new rules, which are generally categorized as anti-retaliation rules, employers must inform their workers of their right to report work-related injuries and illnesses without fear of retaliation. Employers must implement procedures for reporting injuries and illnesses that are reasonable and do not deter reporting. Employers must stop drug testing employees following injuries and illnesses unlikely to have been caused by employee drug use, and they must scrutinize any safety incentive programs currently in effect to ensure they do not deter reporting.
Let me add a couple things here to this particular slide as well. There are kind of 4 bullet points on there, and despite whatever challenges are taking place and quite possibly even further delayed effective dates of these rules, the first 2 bullet points on there I think are things employers ought to be doing anyway. And if you think about it, I doubt very seriously if you were trying to accomplish the opposite. You may not have well enough informed employees about reporting injuries without fear of retaliation, but I'm sure you're not out there threatening employees with the fear of retaliation. So, I mean, it's sort of kind of looking at things from 2 different ways, but they're really things that that we ought to be doing regardless of these rules changing. The other 2 things, though, I think are kind of interesting because I've seen these over the many years. You all will, I'm sure, understand the differences between employer drug testing limitations and opportunities from state to state. What drug testing can be done in West Virginia, for example, might be different from what drug testing can be done in Pennsylvania or Virginia or North Carolina. And all of those distinctions still stay in place. But what OSHA is now suggesting is that any post-accident drug testing that is not based on essentially reasonable suspicion to think that drugs or alcohol might have been a cause of the accident. I don't know whether I should say could be viewed as retaliation or would be viewed as retaliation. And in all likelihood, I think that would be is more likely. Or deter reporting. But either one would be impermissible under these new regulations.
And to give you context, the kind of injuries we're talking about that would not be appropriate under these new rules to do drug testing for would be if an employee comes in and reports, hey, I've been working a lot lately and my back hurts, and that I've got lower back pain now. Well, it's unlikely that lower back pain had anything to do with that employee's drug use, as opposed to maybe like an accident where the employee gets in a car accident. That might involve drug use.
Well, perfect example. Suppose 2 employees are riding together in a car and there's an accident. Maybe a driver might have been impaired, but whether the passenger was impaired or not would be completely irrelevant.
Right.
And so you can sort of see little nuances like that, that I think these regulations, when they do become effective, are going to require you to think through a few of the things that you've been doing or that you may have been doing. The last thing on the slide is something that I have seen for a long time. I've seen a number of employers over the years, and we've worked with a number of employers over the year who have, for example, safety awards, or a safety bonus, or a production bonus that has an element of safety tied into it. So if you don't have any reportable accidents, reportable injuries in a quarter, everybody on the crew or everybody on the shift gets a $100 bonus. OSHA is viewing those types of things as potentially limiting the reporting of injuries, because I've heard this in several cases. Let's say the bonus of 2,000 people at a particular plant depend on not having an injury, and on 5 days before the end of the quarter somebody suffers an injury. Is that person going to report that injury if the other 1,999 people now realize they're not going to get a bonus for Joe failing to report the injury? And that might threaten or intimidate Joe and cause him not to report something that otherwise is reportable.
Right.
And all kinds of employers use programs like that. So that will be significantly effective.
Right. Because at face value, what's wrong with that?
Right. Right. Employers tout themselves as being leaders in the industry for having safety programs that incentivize safe work practices, and those exact safe work practices, or the programs to develop those safe work practices, are now turned around the other way and say, yes, but they're potentially threatening employees or deterring employees from reporting accidents.
Right.
So that could be a big change.
And the way to look at that, there's nothing wrong, I don't think, with having a safety program where you incentivize people to take measures to prevent injuries. The problem is when that translates over to reporting injuries. If the policy is based on how many reportable injuries you have, that's going to deter your employees from actually making a report, or trying to maybe take something that probably should be beyond first aid and say, well, no, maybe this was just first aid, and we're not going to report this one. And that's what OSHA's got a problem with. But all this kind of gets into one of the most important documents employers have as it relates to employees, and that's the employee handbook. Because these OSHA rules talk a lot about procedures and stuff like that. So the issue is where do those procedures go? And the place they're going to go is in your handbook. And of course, your handbook can't be a substitute for any safety manuals and stuff like that. But if you have a handbook, which you should have some sections in there on reporting injuries, and you should have the things we have up on the slide as the bare minimum of stuff that you need to include in any section regarding employees reporting injuries at work. But as the last slide kind of indicated, now we have to look at it and say, is this going to violate these OSHA anti-retaliation rules, or are these procedures I've set up, do they actually deter reporting? And OSHA's had some recent enforcement in this area, and it kind of helps, well, at least helps me to go through and go through hypotheticals to see how this works in reality. So you can imagine an employer who has a policy in their handbook that says employees must immediately report any injuries and illnesses to their supervisor. And for example, while on Tuesday an employee noticed a small splinter in his thumb and he removed it at work, but he didn't report that injury to his supervisor. A few days later, on Friday, the employee's thumb begins to swell, and he visited the doctor for treatment. After visiting the doctor, the employee told his supervisor that he received treatment for a splinter. The next Monday, the employee comes to work, and the employer suspends the employee for 5 days without pay because he violated the immediate reporting requirement by failing to immediately report the splinter to his supervisor. And the question is that suspension lawful because the employer implemented their policy requiring immediate reporting of injuries? And the answer is no. And this is going to be a developing area of the law post when the anti-retaliation rules become effective. But earlier this year, OSHA did go after the United States Steel Court for doing just what the previous hypothetical laid out. They had a policy that required employees to immediately report all injuries to a supervisor, but the policy did not define immediate or injury. And a few employees were disciplined because they failed to immediately report minor injuries like splinters or bumping their head and other small things that they did not immediately, they were not immediately aware that was an actual injury. So OSHA sued U.S. Steel and claimed that those suspensions were illegal. And although U.S. Steel denied that its policy was illegal under the OSHA Act, it did end up settling that lawsuit and paying back wages to all the employees that were disciplined for reporting their injuries. And as part of that settlement, they agreed to rescind the immediate reporting policy they had and implement this policy. So this was the policy straight out of the settlement agreement between OSHA and U.S. Steel, and it kind of gives you an idea of where OSHA is going to go on guidance. And of course, this was negotiated between U.S. Steel and OSHA, two adversaries, so you can't rely on this policy as always holding up under OSHA, but it does give you some insight onto what the kind of stuff OSHA is looking at. So, for example, instead of having it where their employees have to immediately report injuries, the employees have to immediately report injuries within 8 hours after they become aware of an injury. So that makes sense, and you can see how that works with minor injuries, like the employee with the splinter. That employee was not immediately aware that they were injured, but it wasn't until Friday the employee, when his thumb started swelling, that he realized there was a problem. So at that point, he would have an obligation to report that injury to his supervisor under this new policy. And me and Sam were talking about this policy before because, as I said, it's not perfect, and there's kind of some stuff that even we thought in there just seemed odd. And for example, what do you think about the second to last paragraph in there about employees who comply with this policy will not be disciplined for not promptly reporting an injury? It just seems... Yeah,
well, that, to me, is almost nonsensical. Because right. if they've complied with the policy, they wouldn't be disciplined. So, I think that sentence, maybe more than anything else in there, shows that it was the subject of negotiation by two parties.
Exactly.
So maybe neither one got exactly what they were looking for, and they ended up with sort of a compromise. And anybody that's ever dealt with, for example, collective bargaining agreements that get negotiated like that, 5 years after a contract is negotiated, you sit down and you look at it and you ask yourself, who was the crazy person that negotiated this provision? And then when you remember that it was you can then recall how you ended up with something that seems so odd. But it was just the subject of the negotiation.
Mm-hmm. But this policy does have some good, some stuff that every reporting policy should have in it, like the last sentence: supervisors must not interfere with or attempt to discourage reporting under this policy. That's something any injury reporting policy, I would say, has to have in it.
Let me add also, we're talking about employee handbook here, and that's actually what the U.S. Steel case involved. But many of you may have multiple manuals out there. You may have a safety manual. You may have a booklet that you give out to people about workers' compensation benefits. You may have a supervisor's manual or policy guide that provides a little more information to your supervisors about how they're supposed to handle issues that come up. So don't just check your employee handbook.
Right.
Check all of those things that might have information in them about, for example, reporting injuries,
right,
because you're going to want to make sure you've got all of them consistent. And that may seem pretty elementary, but if I had $1 for every time I had a case where I had 3 and 4 different policies and different manuals that said 3 or 4 different things, I wouldn't be here right now.
And obviously another thing that should be common sense is if you go through your policies and you decide, hey, we should make some changes in advance of these anti-retaliation rules or something like that, you got to communicate those changes to your employees. Don't just change them and then assume that your employee is going to go back and read the employee handbook for fun. You should make sure that you go and you tell all your employees, hey, we've made this change and these are the changes to our injury reporting.
And that also can be done in the context of other changes to handbooks and things like that, where you educate people about a series of things, but you're not overemphasizing something that you don't want to overemphasize, or you're not making it stick out like a sore thumb, like maybe you've been doing something wrong all of these years. You're just reviewing and revising your policies.
Right. So based on the new changes to OSHA that we've seen, there's the 4 things that if you were going to go back today to your office and think about as it relates to handling reports of injuries and illnesses, we would recommend that all employers do based on the new changes to OSHA, especially the anti-retaliation provisions. So moving on now to workers' compensation, again, it helps me to understand goals to kind of give me a frame of reference of when I think about individual provisions so I can see the forest through the trees. And with workers' comp, the big goal has to be that you're going to take an employee who suffers a workplace injury and you're going to try your best to return that employee to a comparable in both work and pay job that he or she had prior to the injury. So everything kind of revolves around this general goal. And when we're talking about workers' comp, because there's so many differences between the the reporting and the forms in each state, and I know we have got people on this call from Michigan all the way down to North Carolina and Alabama. It's helpful just to talk about some general principles that we see employers fail to do and how that can actually result in lawsuits related to workers' comp or just prolonged litigation related to workers' comp. And the biggest thing first is communicating with your employees prior to any injury about how they can file a claim for benefits and what to expect. And the whole purpose of this is so that they're not caught off guard or they're not scared if they get hurt on the job of what happens next. I'm scared that I've been hurt on the job and I can't go back to work. Am I going to lose my job? Am I gonna be able to provide for my family? How does temporary total disability work? All of that kind of stuff works a lot better if the employer communicates that to an employee. And the thing I always say as it relates to this is if you don't communicate that to your employees, they will go somewhere else to find that information. And the places they go to find that information tend to be union representatives and plaintiffs' lawyers who are probably going to give them a different spin on the information you could provide to them.
This is, it's a mandatory statutory benefit that employers provide to employees, but it is a benefit that employers provide to employees.
Right.
And, anytime you hire a new employee or anytime you change your, say, health care benefits or disability benefits or anything like that, I would hope that you would have some sort of orientation process to explain how all of that works. And you really ought to include workers' compensation in with that sort of orientation. If your benefits change significantly, you could change workers' comp claims administrators, right? And simply as a result of that change, there might be new information or different information that you would want to tell employees. So I would keep this in the list of things of all of the things that I want to make sure my employees understand they're getting out of this, out of their job here. And this is just one more benefit. And not only one more benefit, but it's a benefit, and we'll get into this in a minute, it's a benefit that has a direct correlation to a lot of other benefits, whether they're health insurance and continuation of health insurance, and whether they're leave rights under the FMLA or rights to reasonable accommodation under the Americans with Disabilities Act. You have to understand how the workers' compensation system and benefits fit into all of these other benefits, whether they're statutory benefits or contractual types of benefits.
And they don't always fit together like you think they're going to fit together. And that's why it's difficult. The same goes for communicating with your employees after an injury occurs. If even if you have it like Stan says, and you've educated your employees on the benefits of workers' comp, but the workers' comp benefits you give to employees, it's still important after the injury to again explain the process, and then always maintain open and frequent communications with the employee to see where they are on their on the path towards the goal we talked about before of returning to comparable work with the employer. And again, it's the same purpose. If you're not communicating to the employees, they're going to seek out third parties to open up those communications to resolve any questions they have. So it's important to keep those frequent communications going so that they can get the information from you as opposed to having to seek that out from other third parties.
Another thing to keep in mind also is that I suspect that probably 100% of you all listening today have a third party administer your workers' compensation claims and benefits. And that person is communicating with your employee on a fairly frequent basis, or maybe I should say should be communicating with your employee on a fairly frequent basis. You should stay on top of that. You need to know what the workers' compensation carrier is saying to your employee. But maybe more important than that is you ought to be involved on the front end of what your workers' compensation claims administrator is saying to your employee. Probably the number one issue that I see in cases that involve workers' compensation retaliation or reasonable accommodation under the ADA or returning employees who've been out on workers' compensation back to employment involves the communication from the workers' compensation claims administrator to the employee. For example, did the doctor who gave the employee a release understand what the employee's job was? Does your claims administrator have your job descriptions?
Right.
For example, if you have job descriptions, and is that person providing them to the doctor so that when you get a doctor's slip at the end of all of this, you're going to know that that doctor's talking about the same job as you're thinking about. But it also relates to the employee, sort of reassurances to employees about, the position being open and trying to get back to work and those sort of things. And I wouldn't you can't just simply forget about the employee and just assume the workers' compensation claims administrator is going to take care of all of this.
Right.
There has to be communication between the two. The employer should not be making employment decisions based on advice given by the workers' compensation carrier because they're administering claims. They're not employers or HR departments. So just keep in mind the two different roles that the employer that HR with the employer plays versus the claims administrator of the workers' compensation plan.
And as Sam kind of got into, we've gone through the process. You've informed the employee about workers' compensation benefits. You've talked to them through their leave, however long that is, and now they're ready to come back to work. So, what are the issues that are going to come up that when an employee comes back to work? And often the employee's ready to come back to work, but it's going to be light duty. How do you deal with requests from doctors of this employee's released to light duty? What do you have to do? Or what do you do if they return with full duty? And these are things that we see come up all the time. because and this is probably where the rubber hits the road so much with managing, workers' compensation, with ADA, and other statutory benefits that you're required to provide employees. First things first, if a doctor releases an employee back to work full duty, or releases an employee back to work at all, don't go back to that doctor and demand a second opinion, or go to another doctor and demand a second opinion. Although there are statutory benefits where you're allowed to get second opinions, like the FMLA, workers' comp is not where one of those situations where you can go out and ask for a second opinion on whether or not your employee is fit to come back to work.
Although that ties in with what I was just talking about, which is you need to make sure that doctor understands what that employee's job is, so that when you get that one doctor slip from the treating physician, you've got at least some assurance that that doctor not only understands, like you don't, what that employee's limitations are, but he understands the same way you do what it is that employee would be expected to do if she was to come back to work.
And then, what if they come back with a light duty slip, and their job is, they can't do light duty on their job. They have to lift 50 pounds normally in their job, but you do have a light duty position open as a night watchman, for example. But they don't want the night watchman position because they have kids, and they have to, and they're a single parent, and they have to take care of their kids. So they reject the night watchman position. Well, in that situation, they're going to forfeit their workers' compensation benefit. So, and that's an advantage of, providing this light duty work available to people coming back, is that, one, it gets them back to work, but, in the event that they don't take that work, it at least, the exposure is cut off from that point going forward. And then kind of tied into that is the idea that employers are not required to bring an employee back to work or create jobs for employees. If an employee comes back and has a light duty slip, and you don't have that night watchman position, you're not required to create a night watchman position to put that employee back to work. And that's an important thing that I think is often overlooked. But what a lot of employers have, and what a thing to think about having is building this sort of strong return to work program where you can assess when someone brings back a light duty work, you can look at, well, what are my business needs? Do I have, I don't have a night watchman position, but we're way behind on this amount of work, and this person, might be able to do it, but she just needs, a day of training. Can we create a position for that employee to one, take care of this business need we now have, and two, bring them back to work with minimal training. So that's something a lot of employers that successfully manage workers' compensation claims have. So kind of related to the last slide, this situation comes up kind of often where you have an employee who suffers a serious workplace injury involving a concussion, and as a result have severe post-concussion syndromes, like they have an inability to walk straight, extreme sensitivity to light, and debilitating migraines. The employer's carrier deems the injuries compensable, and the employee receives temporary total disability benefits and is off of work for some time. But eventually the employee receives a full duty release for the employee to come back to work. And let's say, for example, the employee drives a truck. And the employer, seeing that the employee's job is very safety sensitive, questions the employee's ability to safely perform the essential functions of his job. But you've got the full duty release. What do you do in that situation? Well, you can't go get a second opinion. Like we said before, the workers' comp system is not one where if you get a full duty release from a doctor, you can go back and get a second full duty release from another doctor because you question the employee's ability to work. But when this comes up, it is important to use common sense. If you see the employee coming back to work and he can't walk straight and he's about to climb up into a big Mack truck, you should probably question and talk to him about whether or not he feels all right, and document what's going on. And if you really don't think he's going to be safe to go on the road, then document that and talk to him about it. But getting a second opinion from another doctor isn't the way to go in that situation. And as we talked about before, if that employee comes back with a light duty release and so he can't drive a truck, are you required to create another job for him? Well, no. But can you? Yes.
There's this idea of creating a job. Keep in mind that right now we're talking about workers' compensation benefits. But again, workers' compensation is only one of the factors you have to think about. You've got disabilities under the disability laws, and you may have family and medical leave issues that come up. Jimmy Buffett once wrote in a song, there's a fine line between Saturday night and Sunday morning. And, on this issue of are you required to create a job, I would suggest that you have a person, some larger companies may even have doctors on the staff to help with this. You may have sort of a doctor who's just providing service. He sees patients all the time, but he consults with you about some of these things to help you understand what some of these situations are. But somebody needs to be in charge of keeping track of everybody who's out on workers' compensation, of everybody who's out on FMLA leave, of everybody who's got some sort of disability and at least on a temporary basis can't return to work, and what positions you have available, and not only have available when they ask to come back, but let's just say that that today somebody came in and said, I can't return full duty, I can come back on light duty, and here are my restrictions that the doctor gave me. Well, today, my employer might not have a job for me. But on Monday, my employer might have a job for me, or next Friday. And that stuff slips through the crack all the time. You would be surprised how often, if you interviewed 10 witnesses in a case, 5 of them would say, oh yeah, we got these jobs, we put people in all the time. Well, did anybody, look to see whether this guy could do that job? Well, nobody ever told me. I didn't know that guy could do this job or not do that job. I didn't know he said he was ready to come back to work. And so somebody has to keep track of that and be, in essence, the liaison with your operating people and your maintenance people as to what they can accommodate and what they can't accommodate and what they have available and don't have available, but also what becomes available or what may become available, because your obligation to employees, whether returning from workers' comp leave or whether returning from any of these other kinds of leaves, doesn't end, the second they come in and say, I'm ready to come back to work, and you say, well, I don't have anything for you right now. It continues on, indefinitely, and we see that problem come up in case after case.
Right. Break down the communication, basically, where something was open, or if one person would have had the information, the whole situation that led to the lawsuit would have probably been correct. Never would have happened.
Yeah.
Right. And Sam's we've been hitting, as we've been going along with this, about how does workers' compensation fit in with other sorts of benefits, and what are the issues that come up that we see with that a lot. I mean, one that comes up a lot is FMLA, and you have to go through the analysis of whether you are as an employer actually covered by the FMLA, but also whether your employee is eligible for the FMLA. But assuming you get all through that and you realize that the employee is eligible for FMLA, there's some things that we think that you should always be always recognized in managing workers' compensation claims as it fits up with the FMLA. First, if the employee is eligible, you should have a policy written down somewhere that the FMLA leave is going to run concurrently with the workers' comp leave. So if someone's out and they're collecting workers' compensation benefits, during that same time, they're also accruing FMLA leave. So you have your time on the FMLA, and that will be running while they're also on leave. And the effect of that, and that is okay to do under the FMLA, but the effect of that is if you do that, then all the other provisions of the FMLA are going to kick in at that point. So while the benefits are going to be, the lost wages will be covered up by workers' compensation benefits, the FMLA will obligate you to continue the employee's other health care benefits. While workers' comp, you don't necessarily have an obligation to bring back an employee. In some states, the FMLA would protect that employee's job during the time they're on FMLA leave. So that's another thing and that's only during the time they're on FMLA leave. But we kind of have that note in there, and for our West Virginia employers, this is probably something I see all too often, is terminating an employee who is off on leave for a workers' comp injury. And in West Virginia, that is completely illegal. And as it relates to the last point, something we see a lot and something that gives us a considerable amount of heartburn are workers' compensation discrimination lawsuits. Why do they give you heartburn, Sam?
Yeah.
Besides,
yeah. I would say this wouldn't. I've been doing this 35, 36 years, and I would never have said this 15 years ago, but I think it's true over the last 10 to 15 years. Probably more than half of the cases that I have involved, and most of these cases are in West Virginia, but they're not exclusively in West Virginia right now. And I've done work in Pennsylvania and Virginia and even some other places. You need the law in West Virginia provides very specifically for what rights an employee has about returning to work, whether it's full duty or light duty. And those rules are probably different than most other states. But pretty much most states are going to have a rule that prohibits discrimination on the basis of having a work injury or having a compensable claim. And I would probably say 60% of the cases that I've had over the last 10 to 15 years have probably involved some aspect of I made safety complaints and they fired me. I had a workplace injury and received workers' compensation benefits and they fired me or didn't bring me back. As a result of my workers' compensation claim, I suffer from a disability and they didn't reasonably accommodate. And all of that stuff is related. And in most of those cases, you don't just have a single claim of I was discriminated against because I had a work-related injury. You have all of those claims because frequently the person would qualify as having a disability. They would qualify as having a serious medical condition under the FMLA. You've got compensation issues. You've got benefits issues. You've got return to work issues and that sort of thing. We see it all the time.
Well, that's important. And the last point you had too is super important. Avoiding workers' compensation discrimination not only avoids the obvious workers' compensation discrimination lawsuit, but it avoids the eventual, avalanche of other lawsuits that will be attached to that one claim. Because plaintiffs' counsels like to throw as much up against a wall and see what sticks, and that's what you're going to get, even if the actual catalyst for the lawsuit is a workers' comp issue. And the stuff we see over and over again are refusing or instructing employees to perform available light duty work, changing injured employees' job duties without any legitimate purpose because they're viewed as a liability and you're scared, legitimately or not, that they're going to get hurt again. Taking workers' compensation litigation personally and finding a bad reason or no reason to discharge an employee after they've returned to work following litigating a difficult workers' comp claim. And then in West Virginia, whether you're a West Virginia employer or you have, employees working in West Virginia, discharging an employee under a maximum leave policy, I see all too often.
And that law is going to change from state to state as well. Whether you can even have a policy that provides for termination after some certain period of time, and if you do, whether that would violate, just on its face, is going to violate a workers' compensation law.
Right.
In West Virginia, it would, but even if it didn't violate a specific maximum leave type of statutory or piece of the statute, it still might be discriminatory to apply that type of maximum leave policy.
Right. So as it relates to workers' comp, a few things to keep in mind. Just to summarize what we talked about: keeping communications open with employees before and after a workplace injury, making sure that your employees are working towards getting back to work, because statistically the longer they're out on leave, the longer they'll stay out on leave. Running FMLA and workers' comp concurrently, and understanding the obligations under both, and then educating your supervisors, because it's a top-down process as it relates to discrimination. Educating supervisors on workers' comp discrimination and how to avoid even the appearance of discrimination. And then the last topic we want to talk about today is accommodating disabilities resulting from workplace injuries under the ADA and other state laws that require employers to accommodate employees with disabilities, because of course often workplace injuries create resulting disabilities. If I repeatedly lift a heavy bucket up and down every day for 30 years, I'm going to have a sore back, and that sore back could be, under the ADA, a disability. So the goal here is to make sure that we're providing injured employees who suffer from a disability with equal opportunity and full participation at work. So as I said, workplace injuries often involve disabilities, and what we're talking about in this context is a physical or mental impairment that substantially limits one or more major life activities. And because what we're talking about here is, if we're going to get into the ADA, then we have to get into whether or not the employee is actually protected under the ADA. And only employees that are disabled and qualified are protected under the ADA. And when we say that, those disabled and qualified have, more definitions and meaning than they immediately appear. And qualified, of course, means that the employee is able to perform the essential functions of the job with or without a reasonable accommodation. So assuming you've got an employee who has suffered a workplace injury, as a result of that injury they're now disabled and qualified, that that employee is going to be protected under the ADA and many, if not all, state laws preventing discrimination. So the next question is, if they need changes to workplace policies, what do you do because of that? Changes because of that disability. So what you're required to do, big picture, is not provide the employee with what their requested accommodation, but you are obligated to engage in good faith in an interactive process in which you sit down with the employee and communicate on what a reasonable accommodation would be to allow them to perform their job. And you have to, and that is fundamentally the most important thing in this process of identifying reasonable accommodations. And it's often the one that employers most often fail to do.
That ties in a couple other things we talked about as well, about the extent to which you can get additional medical information. We talked about not being able to go out and get a second opinion, for example, about whether somebody can come back to work or not. But if you're in a situation, in the workers' comp, but if you're in a situation where the person needs an accommodation to do work,
right,
then there's a little more opportunity, not to go get a second opinion, but to get more information from the doctor, right, about what those limitations, right, might be. And, for example, I mentioned before, you might want to educate the doctor ahead of time, so when the doctor gives you a return to work slip, whether it be for full duty or light duty, that you know the doctor understands the position. But let's say you did that. You said, my guy performs in job X. Here's a copy of the job description for job X. The doctor may come back and say, he can't do job X, but he can do these 7 things, or these are the 4 limitations he has. Well, that doctor doesn't know all of the other jobs you have, and so now you have a slip that talks about what limitations there are, and then you've got a bunch of other job descriptions trying to figure out whether that person might be able to do one or more of those jobs. And you may need to go back to that doctor to say, hey, we're glad that you gave us the information you gave us. We've identified, 2 potential jobs that this guy might be qualified to do. Here are the job descriptions for those jobs. Can you tell us if he could do these jobs with these limitations?
Of course, it assumes you have job duties.
Yeah. And I choose as an example, even if you didn't have
job duties.
But
it's an important point.
Right. Even if you didn't have job descriptions.
Right.
Even if you didn't have job descriptions, that doesn't mean you can't communicate with the doctor, either through the workers' comp claims administrator or directly through you, with what exactly this person does or what exactly this other job entails. Yeah, it's great, and you sort of get a presumption of reasonableness of a job description if it's created prior to an injury or prior to request for accommodation. I mean, that's actually in the regulations, but that doesn't mean you can't, on the fly, make up I don't mean make up a job description, but you can make a job description and provide it to a doctor and still get the same result. You may not get the presumption of reasonableness, but you're better. It's better than going blind.
Right, and that's a good point. Like, for example, if I'm an employer, I don't have job descriptions, and I want to do what Sam's saying. How do you provide that kind of information? Well, you might talk to the employee supervisor. Hey, what does Bob? What does he have to do on his job? Does he have to do? Can you give me a list of everything Bob has to do and the physical requirements of his job? And you can make that kind of job description without having to sit down and do this for every single employee right now.
Right. And you could get information from your safety department and the supervisors, and it also ties in with the point that you've got to sort of have somebody in charge who's running each one of these things to ground, so you can make an informed decision.
Right. And then this hypothetical is going to get into kind of our last new topic that's coming up, and new development that we see is coming down as it relates to workplace injuries, and that's maximum leave policies. And a lot of employers have these, where maybe it's 180 days, maybe it's a year, maybe it's 2 years, but employers have these policies where if you're out of work, if you're unable to return to work after a year, we are automatically going to separate you from employment at that point. And the EEOC and we'll get into this, is frowning on policies like that. And so this hypothetical kind of goes through that. For example, you have an employee who's injured on the job and he suffers a serious injury, and then his doctor says, well, he can't work for 6 months. Well, that's okay because the employer provides unpaid leave. So the employee takes unpaid leave for 6 months, and at the end of the 6 months says, hey, I'm still not ready to come back to work. I need another week. My doctor says I need another week. The employer disregards that and says, well, we got 6 months, that's our policy, and terminates the employee after he or she was on leave for 6 months. And the question is, was the application of that maximum leave policy legal? And as I often have to say in questions like this, the answer is maybe. In May of 2006, the EEOC came out with new guidance where they said that under the ADA, employers may have to grant leave beyond the maximum time period of a maximum leave policy as a reasonable accommodation, unless the employer can show doing so will cause them undue hardship. So, assuming that your employee here is subject to the ADA, this employer should have been prepared, or should have at least engaged in the interactive process to determine whether that extra week was a reasonable accommodation, or whether that extra week was going to impose an undue hardship. And chances are that extra week was not going to produce an undue hardship, and chances are that extra week would have been a reasonable accommodation. So in my opinion, I think the application of the maximum leave policy, I know the hypothetical, was illegal under the ADA?
Most likely it's illegal under your state workers' compensation law. It certainly is unlawful under some workers' compensation laws if the injury is, a workplace injury.
And this happens in West Virginia all the time.
Yeah, that we get that all the time in West Virginia. So you've got this sort of interplay between ADA and workers' comp. And this is another thing that I see recurring. Employee comes in and says, my back hurts, doctor told me to be off this week. Next week, employee calls in and says, hey, my doctor told me to be off this week too. Next week, employee calls in and says, my doctor told me I had to be, and it just goes on and on and on and on. And it is difficult. If it's a workers' comp, you sort of have to live with that, because there's very little you can do if that's a workers' comp injury. If it's not a workers' comp injury, then you're back to the, well, if it's FMLA, does he have
job
leave,
protection,
12 weeks of leave still available, or is there some reasonable accommodation to make? Another place this comes up all the time also is, let's say the employee is covered under both the ADA and the FMLA, and the person's been out for 12 weeks, and the doctor says, she can't come back today, but I think she can come back next week. Well, they're out of FMLA leave, but if the person suffers from a disability, you're right back in the same spot.
Right.
Well, in order to make a reasonable accommodation for the disability, not because of the FMLA, but for the disability, do I need to keep that job open for another week? And that's why I think no matter how you look at maximum leave policies, I think in every instance you have to say, is it covered by workers' comp or not? Because that's going to determine, that may be outcome determinative in and of itself in most situations where workers' comp is applicable. Or is it covered by some other statutory provision? Like the FMLA, but in every instance, I think you always have to think, well, no, wait a minute, I do have this reasonable accommodation obligation. Mm-hmm. And what I would do in all of those situations is engage in that interactive process, get as much information as you have, make a decision, and then get on with your life. But get the information first in order to be able to make that decision. Right. Is this something I have to accommodate or not? The doctor says, now, this person is going to be out for an indefinite period of time and may not be able to return to work. Well, then
there's no reasonable accommodation for that.
Yeah, there's probably not much of anything you could do there.
But
if the person's on unpaid leave and the person's not accumulating benefits and all, you may not need to do anything at all.
Right.
You could write a letter and say you're terminated, which is probably going to cause the employee to go get a lawyer, or you can leave the person out there in limbo. I mean, you just need to think through how you want your policies to work. You run into a problem if you're giving people benefits who are out for a long time. There's a disincentive for them to return to work, but there's also an economic cost of your keeping them around longer. But if you're not compensating them and you're not providing them benefits, for some extended period of leave, then letting them be out there on leave, doesn't really result in any, financial adversity to you.
And then this slide, and we want to give you some time to get some questions in if there are any. But this slide kind of goes through the consideration of tying, if you do have workplace training or retraining, how that might work with the ADA, and reassigning employees and whether you need to train them with that. And then again, just a couple quick notes based on what we talked about. Engaging in the interactive process is where employers fail under the ADA. Like Sam said, when you come up on that maximum leave policy, you have to make a decision, but you gotta do your homework before that. You gotta talk to the employee, and you gotta document that interactive process, and then you can make the decision. What we see too often is just making the decision because the maximum leave policy said so. That's the problem under the ADA.
Before we take questions, let me just mention one other thing. Your return to work policy. Again, you have different and competing statutory issues here where if a person is under the FMLA, they have a pretty much an absolute right to return to work. Most people out on workers' comp have an absolute right to return to work. And you've always got these issues about reasonable accommodation. Because you always have a reasonable accommodation issue, and because reasonable accommodation involves a matter of would making a particular accommodation be, quote, reasonable, or would it create a, quote, undue burden on the employer to adopt an accommodation? There is a relatedness in return to work under all of these different provisions we've talked about, because if you create, let's not create, but if you have a light duty work that you give to people who are out on workers' comp, then somebody who's out for a reason that's not workers' comp,
just happens all the time.
For a disability, the question is, well, do you have light duty work, or do you have an accommodation for that person? Well, if you're doing it for half of your workforce, it's going to be very difficult to prove that it would have been an undue hardship on you to do it for the other half.
Right.
And now, you may not be able to do it for half of your employees at one time, but if you routinely make work available to people who are out on workers' comp, and your workers' comp claims administrator is going to be encouraging you to do that, and there may be lots of benefits to doing that.
Right.
You need to be aware that when somebody who doesn't have a workers' comp injury, but has some other disability or disabling type of condition or illness, whether it's reasonable to bring the person back to the same type of restricted duty position you give for someone out on workers' comp leave, or whether it would be an undue hardship on you to do that. And I would just submit to you that it may be very difficult to argue undue hardship when you've done it on a routine basis.
And what he's talking about is we see this a lot where employers say, we offer light duty work for people coming back from workers' compensation leave. We do not offer light duty work for people coming back from other sorts of medical leave. And the problem with that is it makes it very hard to defend the decision to accommodate one group of people but not accommodate another group of people.
And employers used to do that all the time.
Oh yeah,
they used to always do it for workers' comp but not do it for others. Yes, you're right. Some employers still do it, but I think I think that can give you some major heartburn there too. That creates all kind of problems, and that creates that probably creates more problems than this last one. But that thing that I'll mention, but we still see it too, is employers who say, "Oh, we don't have light duty." Anytime somebody says, "Well, I need this light," we don't have light duty.
Right.
And that's completely unacceptable in the sense of you've at least got to look at it on a case-by-case basis, see what the restrictions are, and whether you actually do have something that person could do, whether it's return from workers' comp or somebody who's just out on a disability. But if you've got supervisors who are telling people, "Oh, we don't have light duty," you're probably sending the wrong message, and from an employee relations standpoint, but also from a legal standpoint on all these different things that we've talked about.
Right.
Okay, we have a question. It says, if an employee has FMLA for a completely different issue that is not related to the workers' comp case, the FMLA would not run at the same time as the worker comp time off. Is that correct?
I think the question is, I have a workers' compensation injury and I'm out, but I also, while I'm out, develop a serious health condition. I haven't seen that, but I do think it would be a little bit risky to without looking into it in more detail, to treat that absence as FMLA. If the workers' comp injury occurred first, because that would be the reason the person was out, you might have a serious health condition, but the serious health condition is not the reason you're out.
Right.
And so I do think the reason you're out would govern whether you could use or require the use of FMLA leave.
You could see where you'd want to use it, or the employee would want to use FMLA leave because, you know, under a lot of workers' comp statutes, their job is not protected.
Right.
They have an unlimited leave, but their job's not protected. Or FMLA, their job would be protected.
Well,
you know, you could see a situation where an employee, you know, is out for 6 months, is coming up on that maximum leave, and then decides, you know, suddenly they have a serious health condition and they want to take FMLA leave now going forward. You know?
Yeah, I think they'd be able, yeah. Well, but
the first problem is you're not running, you should have been running FMLA leave concurrently already for the workers' comp. So that's why you do that, because at that point you could say, well, you are eligible for FMLA leave, but you've already used your 12 weeks.
Yes, but I think the distinction in the question is if you were out on workers' comp leave and the reason you would be qualified for FMLA leave is the same reason, then the employer can require them to run concurrently,
right?
Or the employee could ask that they run concurrently. But if you were out under a workers' comp leave, and at sometime toward the end of your workers' comp leave you develop a serious health condition, I think you would have the ability, if you haven't designated
right.
it as workers' comp leave or FMLA leave, that you'd have that ability to use it.
I think
on the back end.